I am Sahar Aziz. I am a professor of law at Rutgers University. I'm also the founding director of the Center for Security, Race, and Rights, which is the host of this teach-in series. The Center for Security, Race, and Rights is the first center, civil rights center, housed at a U.S. law school that focuses primarily on the civil rights of Muslims, Arabs, and South Asians through a cross-racial and interfaith approach. This series is part of our mission to ensure that we cover issues of race and rights and security, which includes physical safety and personal safety from state-sanctioned violence of minority communities. And in this particular historical moment, we will be intentionally focusing on African-American communities and also learning at how the way in which African-American communities have been systematically discriminated against by private and state actors. It's important for us to understand that in order to understand how other minority communities are subjugated and oppressed in the United States. So I would encourage you, if you are a Twitter follower, to follow us on RUCSRR, Instagram, Rutgers CSRR, and on Facebook.com/RUCSRR. And before I kick off the event, I would ask anyone who is participating in today's teach-in or the two teach-ins we have coming up on June 24th at 4 p.m. featuring Gina Shaw on social justice lawyering during a pandemic and uprisings, and also on July 1st at 4 p.m. featuring Professor Vernelia Randall discussing intergenerational systemic racism. And so whether you're participating today or in these two coming up, we always welcome your donations and your financial support, and you can do so at csrr.rutgers.edu and press the donate button. We are intentionally making all of our events free and accessible to the public, but as you know, putting on those events are not always cost-free, so any support that you can provide is most welcome. And so with that, I'd like to turn to our esteemed speakers, and I will introduce them both, and then we will have them present each in order for about 25 to 30 minutes, after which we will have hopefully a robust Q&A until 6 o'clock today. And hopefully all of you can stay at least until they finish their presentations, and you're more than welcome to engage in the Q&A. So we have Professor Anthony Farley and Professor Benjamin Davis, both of whom I personally highly respect and highly admire, and frequently cite their work, read their work, learn from their work, and cite their work. So it's especially a pleasure and an honor for me to host them today. Professor Anthony Farley is the James Campbell Matthews Distinguished Professor of Jurisprudence at Albany Law School. He was the James and Mary Lassiter Distinguished Visiting Professor at the University of Kentucky College of Law and the Andrew Jefferson Endowed Chair in Trial Advocacy at Texas Southern University's Thurgood Marshall School of Law. The Haywood Burns Chair in Civil Rights at CUNY School of Law in 2006, and a tenured professor at Boston College Law School, where he taught for 16 years. And this past year, Rutgers Law School had the pleasure of hosting him as a distinguished visiting professor, where he taught the new Jim Crow and constitutional law. Prior to entering academia, he was an assistant U.S. attorney in the office of the U.S. Attorney for the District of Columbia. And prior to serving as a federal prosecutor, Professor Farley practiced law as a corporate securities associate with Sherman and Sterling in New York City. After Professor Farley's presentation, we will then hear Professor Benjamin Davis, a University of Toledo faculty member since 2003 and tenured since 2008, is a graduate of Harvard College, Harvard Law School, and Harvard Business School, where he was articles editor of the Harvard International Law Journal. Professor Davis teaches in the areas of contracts, commercial law, alternative dispute resolution, arbitration, public international law, international business transactions, and a 3L extended bar preparation. Professor Davis led the successful effort in the American Society of International Law to pass only the 8th resolution in its history, entitled the ASIL Centennial Resolution of Laws of War and Detainee Treatment. Professor Davis has given numerous presentations and speeches around the world. He is a contributing editor at Jurist, He has published dozens of articles on topics related to international and domestic arbitration, online and offline dispute resolution, and international law. And to be honest, we could probably spend another 30 minutes talking about both Professor Farley and Professor Davis's impressive achievements, extensive scholarship, and deep expertise. So I think it goes without saying that we are very, very fortunate to have both of them here today. So I will start. Professor Farley, the title of his talk is Confronting COVID-19 Professor Farley's talk will be called The Sickness Unto Death, the American Psyche since 2016. Professor Farley, you have the floor.
Hi, thanks for inviting me. I'm really happy to be doing this. It's a pleasure to join Professor Sahar Aziz, and it's a pleasure to know that this event is going to be a success no matter what I do, because Professor Ben Davis is taking part. So Sahar has asked me to speak generally, to speak about legal theory, and so that's what I'm going to do, to talk about the present moment and why it is that we seem perpetually stuck in this awful present moment. I'll also say that the moment at present is a lot less awful than anything that has come before. We have a lot of reasons to hope right now. So, gosh, I was going to, some people might have guessed from the title, start off talking about Lazarus, right? That my title said the sickness unto death. There's a moment in the Gospels, and I'm not speaking to you as a theologian. I'm reading theology these days because it seems as though the evils we are now confronting are so vast, so terrible, that our everyday language lacks the capacity to describe what it is we are seeing. There are two mentions of Lazarus, two different Lazarus stories. There's the Lazarus who rose from the dead in John chapter 11, verse 4. There's also the sickness is not unto death. There's a Lazarus who was dead and for whom it was in fact too late. Too bad for that other second Lazarus, the rich one who found himself in hell because of his lack of kindness and his lack of real ties to the world of the living while he was living. That one tries to warn his living kin, but it's too late, says the main figure in the Gospels, Jesus, because if your living kin didn't believe when they saw miracles, they're not going to believe when they hear a warning. That will just be more words for them. Why bring up Lazarus, the two dead figures named Lazarus in the Gospels, the one who rose from the dead and the one who was dead? I think we have been dead for a long time, and we are now, in fact, rising. There are some among us, however, for whom the sickness is, in fact, unto death, and there's nothing else for them. Those are the ones that say, we're doing too much, that the changes we're asking for are too much. Those are the ones praying for not emancipation, not salvation, not redemption, but praying for a return. Make America great again. The people praying for that return are like the second Lazarus, the one who is dead and who, though they see these miracles now occurring, miracles of cooperation, miracles of optimism, well, they are not with us. Pull down every single slave master's monument. Leave the statues on the ground broken. Mark the day they were smashed by plaques, banners, prayers, songs. Let the broken pieces be the new monuments. Institutions are also statues. Like those institutions that oppress us all need to be broken apart. Let's leave the broken pieces on the ground, so to speak. Let's mark the day they were smashed with plaques and banners and prayers and songs. Let the broken pieces be our new monuments. The institutions that have been holding us down cannot be reformed. Realizing that is the key to ending the cycle of repetition that has kept us back. This always winter but never Christmas situation, to quote the Chronicles of Narnia, that we have been in. Abolition is goodbye to all that. Abolition doesn't compromise. Abolition is not reform. Reform ends up being repetition. We have seen now, through the power of technology, video of police atrocities. No one has to rely on word of mouth anymore. You can see it with your own eyes. We can also see another thing. We can look at each other as we see these videos, and we see that some of us have enough of an inner light, enough of a capacity for fellow feeling to be shocked at what we see is standard operating procedure in every police department in the country. But we also see that some of us watching those same films are unmoved by anything except perhaps a kind of make America great pleasure as they see police officers killing people in the street with more or less impunity. Less impunity now than before, but abolition is goodbye to all that. Not reform of police departments or prosecutors' offices or prisons, but abolition of police departments, prosecutors' offices, and prisons, solving our problems another way. Well, this is a waking up moment, and that's why I think it's a hopeful moment, despite horrors like the 8 minutes and 46 seconds George Floyd had to endure on camera and under the knee of a police officer who was surrounded by other police officers. Despite that, there's now cause for hope, for freedom dreams, as Robin Kelly puts it, to come true. One day long ago, my daughter and I went to the zoo. It's long ago, I think she was 2. And I remember she reminded me of this trip by saying, the lion was sleeping, remember. Where there are lions in cages, there's history and conflict. So sleeping lions is a great place to begin, because I think, well, we all sleep from time to time and with regularity. Sleep comes to people in palaces and to people in low places, to people in bondage, as well as to people who are free. Sleep is the most universal of republics. Where there are lions and cages, there's history and conflict, there's trauma, repetition, transference. This is getting into the law part of my discussion. Where there's history and conflict, there's everything needed for the bringing into being of this weird transference relationship that we see in law. In transference, you repeat a prior relationship through a current one. The transference relationship is neurotic, and it happens to groups as well as individuals. It's true in psychoanalysis, it's true in jurisprudence. In psychoanalysis, the neurosis may be contained in the analytic situation. In the real world, it's often contained in the juridical or legal situation. But we have to look more closely at that legal situation. Transference is a reflection of the past. It has the potential, though, to become a reflection on the past. What can we do to to free ourselves from the cycle of repetition we're in? Courage is required to interpret what has happened before. Our ability to interpret our freedom dreams is the kind of help that lawyers may be able to bring to clients. We're experts in legal methods, yes, but we are also part of society and therefore caged and therefore prone to the same symptoms as everyone else. That doesn't have to be cause for despair. 2 or many can sometimes gather together and regain their shattered completeness. provided that their sharing, insight, and blindness takes place in a kind of free association, coming together in the spirit of mutual aid and direct action, as when we pull down every single slave master's monument or every single institution that has come to us from that time, and leave the pieces on the ground broken, marking the dates with plaques, banners, prayers, and songs, and letting the broken pieces be our new monuments. The lion was sleeping. Something in the freedom dream awakes the dreamer to a duty that has to be performed in the real world. The dream is possible, it seems, only within sleep, but the duty requires an awakening. The lion was sleeping, remember? There's a science of law, but its method, legal method, turns out to be that dream repeated. Sleep brings dreams. If lions are subjects of the kingdom of dreams, as they are subjects of the republic of sleep, then what dreams may come also to lions. I'm really pushing this metaphor because I don't really believe it's a metaphor. Even to such lions as may be forced to sleep in cages. What is a cage to a dream? Dreams are the free citizens of the universal republic of sleep. Nothing can halt their comings or goings. A lion caged and sleeping may have been so since birth, but dreams are born free and so must remain so forever. To dream in a cage is a kind of freedom. And if caged lions dream, they dream about freedom. But the official histories of captivity contain few, if any, usable records of such freedom dreams. And this carceral lack, this lack of freedom experienced as a lack of words, is the beginning of lion literature. Lion literature, what are you talking about? Well, the official histories of captivity law don't contain these freedom dreams. There's a line in Proust where he looks at soldiers marching off to war and says, they have no fear of death left in them. They're nothing more or less than madmen, and they aren't worth the price of a rope to hang them with. They're not men anymore, they're lions. If it's true people can be turned into beasts, and Proust says they are, that's true, then it's also true that lions can speak. Abolitionist attorney Wendell Phillips, introducing the narrative of the life of Frederick Douglass, an American slave, written by himself, witnessed one such lion. Wendell Phillips, if you've read Frederick Douglass's work, introduces Douglass by telling us, you remember the old fable of the man and the lion, where the lion complained that he should not be so misrepresented when lions wrote history? I'm glad the time has come when lions write history, said Wendell Phillips, referring to Frederick Douglass's narrative. I think that's the time we are now in, where we see abolition replacing reform, where we see people in the spirit of free association and mutual aid taking direct action to pull down every single slave master's monument and leave, if they take care to leave the pieces on the ground, broken, marking the dates. They were smashed with plaques, banners, prayers, and songs, and letting the broken pieces be our new monuments. So I think in this dismissal of the idea of legal reform, we are seeing something new, or at least something not seen since 1968, since April 5, 1968, the day after Martin Luther King's assassination. Let me turn, mindful of the time, to the idea of forgetting. Emancipation never took place. Neither Frederick Douglass nor any child of his pride who followed after ever managed to escape slavery. The endless night of slavery is still falling, and we, the fallen, have managed only to perfect our degraded position. Time has not passed. We say we have made progress, and there are many monuments to progress. But these monuments to progress, like the monuments to the slave masters, are monuments not to our future, but to our buried, dead past, the death that we're continually forced to live. Because what is it to live within a cage other than to be subjected to a kind of living death? How does it work? When we say we've made progress, the typical narrative is we've gone from slavery to segregation to the new Jim Crow, and that's treated as progress. It is in fact white over black slavery to white over black segregation to white over black the new Jim Crow. White over black to white over black to white over black is not progress. It's the motionless movement of death perfecting itself. Calling that progress is to submit to our own undoing. And slavery is death, death only, and that continually. Nothing escapes slavery. Nothing escapes that timeline. Sometimes it seems someone gets away apparently unharmed from an accident, from a death they only belatedly and incompletely apprehend, only to develop a neurosis or a psychosis, a repetition complex. The middle passage, slavery, is akin to such an accident. In the history of emancipation, the struggle for equal justice under law is just such a neurosis. Or when slavery finally perfects itself, just such a psychosis. The slave is made so by law. The slave following emancipation makes law, and that law in turn makes slaves who make laws that make slaves who make laws that make slaves, and so on and so on. The instrument of repression, the equal rights that are thought to turn away this white over black imperative, becomes the vehicle of return for that same imperative. The emancipated slave endlessly defers the emancipation by its endless deference to rule of law. That deference to rule of law can be described as a preference for reform, for working within the established order of things, for not taking direct action, for not moving forward in a spirit of mutual aid, for not pulling down every single slave master monument, for not leaving the statues on the ground broken, for not marking the dates they were smashed with plaques, prayers, banners, and songs, for not letting the new pieces become our new monuments. Abolition is goodbye to that cycle of endless repetition. Look, how does that repetition work? The oppressed get together under the banner of their oppression, race. We meet, we paint a picture of a prettier tomorrow. We paint it in terms of an executive order or a legislative act or a win in the courts. Sometimes we actually win. But this win is always going to come in the form of a text, some written document that someone has to interpret and impose. Who interprets it? Who applies this to the world? We don't, or we wouldn't have needed to pray in legal relief to some power that isn't us. We'd have been fine in the first place if we were the power. And when on bended knee the slave prays for legal relief, the slave may win here or there. An executive order, a legislative act may come through, or a win may be had in the courtroom. But that text is always going to contain gaps, conflicts, and ambiguities. The gaps, conflicts, and ambiguities will be read against us because everything is against us. That's what it means to be so universally despised that you can get together under the banner of color across infinite other differences. So, in less lofty terms, you can think about Linus and the football. She's going to pull it away no matter what fancy words precede. Charlie Brown and the football. no matter what fancy words precede Charlie Brown's kicking the football, Lucy is going to pull it away at the last moment. So the slave then professes death through its appeal to law, an appeal that takes place only after its so-called emancipation. After the emancipation, the slave bows down before the law. The slave prays for legal relief. The slave thus submits to rule of law. The rule of law is in fact the slave's own creation. The rule of law is a trauma-conceived idea that escapes the slave's mind only to stand over and above that slave as a kind of earthly god. The slave only truly becomes a slave after its so-called emancipation, when it bows down in prayer for legal relief before the door of the law. The lion, caged, can't help but wonder what it has done to merit the terrible trespasses committed against it. The lion, its skin having been sold whilst it was still in it, now begins to work, hallucinating future relief from captivity in the form of law, and it thus earns its future confinement. The commodity that the lion produces via its work of hallucination is law, right? So, gosh, why all this talk of lions? Well, the lion was sleeping, remember? What would happen when the lion wrote history? Well, maybe that, no, I shouldn't use the word maybe, that's too soft a word. That day is coming now. We're seeing lions write history. Everywhere we see people refuse to speak in the sweet, sweet language of reform, and instead talk about direct action, free associations, in a spirit of mutual aid against the institutions that we have inherited from slavery. Prison looks like the middle passage because it is the middle passage. Our police departments, as we've seen, cannot be reformed. Our district attorney's office, our prosecutors cannot be reformed. 95% of elected prosecutors in this country are white. Nearly 80% of those are white men. 3/5 of the states in this country have no Black elected prosecutors. There are 14 states that have no elected prosecutors of color at all. Only 1% of all prosecutors in the country are minority, are women of color. Even when we diversify seats on the bench, positions in the prosecutor's office, positions and police departments, there's no evidence that the inheritance of slavery goes away. More diverse police forces, great idea, but the diversity doesn't produce less violence against Black citizens. The officers who are selected to make those departments more diverse, after all, are the officers selected and promoted by departments that have been happy forever to not be diverse. So the thin blue line holds. This is all violence, right? I've talked about the kind of violence that we saw being committed against George Floyd, the direct violence. This direct violence is terrible as direct violence. It is also terrible as symbolic violence, because as symbol, it begets more direct violence. It also begets indirect violence, other kinds of structural violence. Children are still drinking water with lead in it in Flint, Michigan. That is violence. The median net family the median net family household worth for Black families in Boston is $8. Enough for Starbucks for 2, not Starbucks for 3. That too is indirect violence. The symbolic violence we see acted out by the police begets, the direct violence acted out by the police begets a kind of further acts of real violence, which we have seen with vigilantism. And also, it enables indirect violence because people can see that Black lives don't matter when the police are able to commit these kind of actions with impunity. Well, look, if you remember C.S. Lewis and the Chronicles of Narnia, you remember that with Aslan, he was a good lion, but he wasn't a tame lion. With what we see now on the streets, with people taking direct action, the Black Lives Matter and other groups taking direct action, this is a good uprising, but it is not and should not be a tame uprising. The abolition is the word Frederick Douglass searched for when he realized his masters didn't want to discuss it. Abolition was goodbye to all that. I think we may now be seeing in the rejection of this spirit of reform and repetition, a kind of waking up from sleep, like the first Lazarus, not the second, who was dead and gone, and his supposedly living relatives were living, but still actually dead and gone because it was too late for them. But for those of us for whom the time has not run out, I hope we all join these uprisings, which are good and not tame, and which have the potential, I believe, to pull down every single slave master's monument. I hope we leave the statues on the ground broken and mark the dates they were smashed with plaques, banners, prayers, and songs.
Thank you, Professor Farley. You've given us a lot to think about. We are going to first go to Professor Davis before we go to Q&A, but I can't help but just pose this rhetorical question, which we can talk about during Q&A, which is, all three of us are law professors who are teaching future prosecutors, future judges, future lawyers, and train our students to seek those executive orders, legislative acts, and wins in the courts. And so you have certainly left us with some cognitive dissonance as to how we reconcile what we do at law schools, right, with the shortcomings, to put it nicely, of legal reform and how that has not, in fact, produced what may need to be produced in the form of abolition. So I will just leave it there. And now I will turn it to Professor Davis. And the title of his talk is Confronting COVID-19, State Pandemic Insanity, the Case of Demonstrations. Professor Davis, you want to turn your camera on? Uh-oh, we may have lost Professor Davis. Okay, well, while we figure that out, Professor Farley, we have a couple of questions, which, well, one of them was echoing what I said. You know, how as members of the legal community do we reconcile the shortcomings of legal reform? Where does this leave us as legal academics and law professors and law students, many of whom are participants and listening in today?
Oh, you wanted me to answer that?
Yeah, go ahead, because we're trying to get Professor Davis back on. There seems to have been a little disconnect there. The joy.
Oh, okay. Well, sure. It's the one of the greatest things to ever happen in America was the industrial workers of the world in 1905. Right? If you read their 1905 Constitution, it's a fantastic thing. They were a radical union. We don't even know what a radical union would be anymore, but they had the idea, they had a bunch of fantastic ideas that they were going to build the new world within the shell of the old. That they were going to fight for better wages, hours, and working conditions, like every other union, but they weren't going to lose sight of the fact that the bosses had to be dumped off our backs. That the world, that nothing actually belonged to the owners, because nothing belongs to anyone. They had the idea that there should be a grand industrial union of all the workers of the world, leading toward a general strike where there is an end to ownership and an abolition of the wage system entirely. So abolition of the wage system wasn't a thing on the general strike. That wasn't a thing on the agenda for the next day or the next. But it was something they had forever on their mind so that they weren't compromised and locked into a cycle of endless reform and repetition. So while some unions may have other unions limited themselves to better hours, wages, and working conditions, the industrial workers of the world in 1905 were looking for everything. I think my host has disappeared.
No, I'm here.
Okay, all right.
Okay.
I wasn't sure how long an answer to give, Sahar.
No, that's fine.
Right.
So is there, for those who are listening in, we have 184 participants. Please feel free to use the Q&A. We're gonna change it around a bit until Professor Davis has got some technology problems on his end. So we're gonna kind of split up the Q&A. So this is your turn to critique Professor Farley.
Oh, so I should say this with the wobblies then, just to make sure this point isn't lost, that I'm likening the idea of the legal tasks that our students' clients may call upon them to perform to the struggle for better hours, wages, and working conditions. And I'm hoping that we can inspire those students who are looking to us for inspiration. Not all of them are, but the ones who are looking to us for inspiration, that's most of them, that there's more to the struggle than just better hours, wages, and working conditions within the system. It is possible to abolish it altogether. And it's possible now to build toward its complete abolition. Like there's a serious conversation now about whether we need police, right? We can look at their training and modifications of the training and saying, hey, why are we hiring peace officers who don't have degrees in peace studies? Why are people patrolling multicultural America who only speak English? Why are people out there without degrees in social work doing social work? Why are they carrying guns into peaceful places? Why are we hiring the kind of people who feel comfortable carrying weapons? Right? Peacekeeping is a skill. We've all been in groups where some people show their ability to de-escalate, a natural ability to de-escalate. And those people can be trained to become to a kind of virtuosity of de-escalation. Those aren't the kind of people who are attracted to weapons. So let's disarm the police. That's a real conversation now. Let's defund the police. Why are we spending money on the production of social disorder? Let's deprogram the police. We have such a violent culture, and our images of policing are part of that violence. that needs serious deprogramming now to get back to what would be healthy. Let's disband the police. There have to be other ways that a mature society deals with its problems than men with guns patrolling the streets. You're on mute, Sahar.
Oh, sorry. The questions are now starting to come in. So I'm going to read 3, and you don't have to answer all of them.
Okay.
And some of them are comments. Thanks, Professor Farley. Fantastic. I have a question. Can you speak a bit more to the monuments on the ground and the songs, the prayers as a form of life, and this life's connection to abolition? That's one question. Second question, are all the institutional gestures of anti-racism, such as various public figures taking the knee or organizations changing social media pictures to black squares, just another way of hiding, another way of hiding the structural injustices? In other words, is institutionalized anti-racism just another implicit form of institutional racism? Can we ever get out of the issue of false consciousness?
Oh, those are great questions. Anti-racism can become racism in a minute, right? This is what I meant when I said that the reform that comes in the form of a text is always going to contain what Duncan Kennedy, back in the days of the critical legal studies movement, described as gaps, conflicts, and ambiguities. Those gaps, conflicts, and ambiguities are going to be resolved in the direction that the power wants them resolved. So when the power looks out and sees it's in trouble, that those 8 minutes and 46 seconds struck a real chord in people, and the outrage may not be willing to go back into its cage, then people offer us reform. And the reform may have a kind of anti-racist tone. It may even, look at all the institutions declaring themselves anti-racist in a way that is a shock and surprise to the Black people in those institutions. So it's easy to say we're all anti-racist now. It's a lot, that doesn't mean anybody is anti-racist. And the anti-racism stuff can come back around, right? We see police officers nowadays making themselves into minorities, saying that we're not getting our proper respect. You know, where are our rights as police officers? It boggles the mind, really.
Okay. How does the change in language affect legal and systemic racism? Words like lynching and abolition instead of murder and reform. So that's one question. Somebody else had a comment / question. I was reading The Soul of Black Folk and the caged lion analogy, not realizing he was a slave until freed. The legal bondage that occurred by the way they were forced into debt was worse. Is that similar? And then finally, do you think our religious leaders should have had a bigger voice in our political unrest, especially with those multi-million-dollar memberships? And I'll have you answer this round. And we have Mr. Davis back. Okay, wonderful.
All right. Hooray!
So why don't you hold on to that, Professor Farley, and I can always ask the questions. Good to have you back, Professor Davis. You have to be.
Hello, everybody.
When you're doing these online. Thank you for the participants' patience. Okay, we're ready. We're ready for you. You got 25, 30 minutes. And then we'll still have time left over for Q&A. So the floor is yours, Professor Davis.
Okay, and first of all, I just would like to say to Sahar, thank you very much for your patience. So everyone out there, you can hear me all right? You can see me okay? Everything okay from that end? Great.
Yes.
Excellent. I I had a weird thing with technology, which was that it didn't allow me to mute or to open the video or unmute. So I had to kind of come in several different times. Finally, here we are. So thank you, Sahar, Professor Aziz, for allowing me to be part of this. I'm particularly appreciative for the fact that you're organizing this. You've been doing wonderful work around the world for a long period of time, and that you're doing this at Rutgers, which I definitely really do appreciate, because I'm a East Orange, New Jersey kid. And so being back in the sort of New Jersey space a little bit is great. And thank you for having me have the opportunity to be with Anthony Farley here. He is a remarkable person doing quite remarkable work. And I really have enjoyed, we were colleagues together for a visit at Albany at one point in time. And so I look forward to my few comments that I will add here that I hope will be of assistance to the discussions that we do. So with regards to my topic, can you all see me okay? Is that all right? Okay? Everything's okay?
Yes, you're good.
You're good. Okay. All right. So my topic for you all is about the recent events that are happening that are here. And there are a couple things that I maybe would just like to highlight to you to speak for about, I guess, 20 minutes here on this topic. The way my presentation is going to be done is it's basically got 3 or 4 parts. One is to talk about a couple of things that have happened the last day or so. 2 is to talk about what we think about as Americans in terms of vindicating rights. 3 is to suggest the way we should think about vindicating rights. And 4 is to think about all this with the overlay of COVID-19. Or as I like to say, everybody say, Corona don't play. All right? So let us start out with the first some very recent events that have happened. And I'm borrowing from Anthony Farley's presentation about taking down slave statues for this point. And somebody, one of my former students, sent me a nice little picture that I posted on my Facebook, which says, if pulling down a statue of a slave trader ruins your way of life, quote unquote, you are either a racist or a pigeon, okay? So you have to decide who you are. If you've got a problem with pulling down these statues, are you a racist or are you a pigeon? Look at yourself. The second thing that just happened this past June 14th, Sunday, in a town called Bethel, Ohio, which is near Cincinnati, there were about 20 to 25 Black Lives Matter protesters. You may have seen that. You may have seen that a guy was standing there alone, nonviolent, and a white guy, just for purposes of everybody out there, and standing there nonviolent, some guy behind him punched him in the back of the head, and there was a police officer who was right there, and the police officer didn't do a doggone thing about it. And apparently there were 700 or 800 counter protesters who were on motorcycles and all that, who are really upset with this Black Lives Matter thing. So there's a situation where there's a white guy who's standing there, nonviolent. He gets cold cocked by a guy behind him. There's a police officer. You can see his hat in the actual picture if you go to the web and look at it. And the police officer does nothing to address the assault done on this guy who is standing there. And that, in a nutshell, is an emblematic image of some of the difficulties that we have in the United States. So those are 2 particular pictures to try to highlight this idea of where we're at and to try to think about what is maybe a movement that is developing here. Now, with regards to how we think, basically, when you talk about vindicating rights in the United States, everyone in the United States basically thinks of 1 or 2 things. Going into a state court, going into a federal court, that's what we teach in law schools all the time, and bringing some kind of claim. How does that happen? Well, you know, as us as individuals can bring a complaint against somebody, or we can possibly create up a class action, civil type operation, those kind of things we imagine. and try to find some law that works, that vindicates the rights there. That's what lawyers do. They get facts, and as you know, they find, well, can I run this as a Bivens claim? Can I run this as a wrongful death claim? Can I run it as something else? Anyway, the point is, you try to find some way in the either state law or federal law to vindicate those rights as an individual. And those could be cases where you try to vindicate rights against a police officer or some officer of the executive or legislature, possibly even the judiciary, but there are limits on all these things when we talk about immunity. The second way is that the state, either at the local level or at the state level, decides to take up the cause of some problem and either in civil or, if it's bad enough, criminal level, take up that case too. Now, it is also possible that states might bring such claims against the federal government with regards to certain things the federal government does, either as civil or in principle criminal action against federal officers. We can talk about that too in due course. Finally, we have the federal level, where the federal level can take on a civil complaint of some kind, what's permitted under the various federal codes. Or obviously we have the Justice Department doing criminal complaints at all. So we see all those kind of methods through the courts. And one of the issues that's just generic with regards to those kind of methods in the United States in particular, and I think is probably endemic to our problem, is really simple. For the most part, in American law, we try to look for intent. We look for intent, obviously in the criminal space, but in other areas, intent to discriminate, intent to do this. There's a little bit of a disparate impact stuff that happens maybe in some places. But we're very focused on intent, trying to find intent, which can be hard to do. And even though there may be something that is awful that is happening to somebody, but there was an intent to cause that thing to happen to the person. This contrasts with the way we could look at it in other visions. But the point is that if you're focused on intent and you're trying to go to court for these kinds of actions that I've tried to describe on, you have some difficulty succeeding with regards to it, irrespective of whether there's some kind of immunity that applies or not. So what happens is that when people see things that have an enormous effect on them, they try to go other ways, either in the political, trying to talk to the legislature to get a law changed, or try to get the executive to change the way it does things. All those kind of things are to try to ameliorate whatever the effect is at the state or federal level, to try, in some cases, deal with the effect, whether or not there's intent. And that's a battle, because there's, on the one hand, people saying, hey, we didn't intentionally do this. Okay, but let's fix what you do. So, one of the examples you're seeing now is they're talking about defunding the police or reforming the police, more police training, all this kind of stuff. That's basically working on the executive to improve that structure. Maybe having some legislative changes, banning chokeholds, for example. That's an example of trying to get the legislature to change a rule. So this is the way we do it in the United States. Basically, looking for intent, and then when there's an effect, we go to the street and we try to see what's there. And as you've seen in various cases along the way, when you try to go after somebody who is an official, an officer, or something like that, you have a number of hassles. One of them being that if you're the individual bringing the complaint, maybe there's not a basis for you to bring the complaint or in the local law. I saw that, I think in the state of Colorado, they're getting ready they're working on having basically a state, what's called 1983 kind of civil rights action that could be brought there. But which means that prior to that, it's not clear that in state court you'd have some kind of civil rights action to do there. So state by state, you have to look at what you can do with regards to complaints. You can make, obviously, complaints about police officers to the police department, then they review what's going on there. There's a whole issue of how that process goes forward. You might have a community board that you can make complaints to. And then the question is, what is the authority of the community board? All these things come up as complications that you have to deal with as an individual trying to do these things. If you're going down the path of state, again, it's a question whether the state wants to take this on. I've never seen a governor of a state or somebody who's attorney general or whatever running on the platform that I am a strong supporter of human rights. They're always tough on crime, that gets you elected. So obviously, and they look for getting the police unions support with regards to what they're doing. And so, you know, you never see them really going the other way of saying, no, in fact, I'd rather make sure I respect human rights in everything that I do. So that's another structural dilemma. And of course, you have at the state level, and essentially a number of states, you have the district attorneys, the local attorneys in the various towns. They're elected officials too. And I've never seen a district attorney's ad that has said, I am here for human rights or civil rights. They're always trying to show they're, you know, tough on crime and whatever that means in our lexicon. All right. Beyond that, you have also elected judges. And I've never seen a judge who is going up for election who's done a campaign saying, I'm for human rights. It's always about, I'm tough on crime and I will keep you safe kind of notion. So you got this kind of structural reality that's there. And if a judge does start to talk human rights or that, they're sure to get ads from the other party or something like that saying, this judge is soft on crime or something like that. So this is a pressure that's there that's kind of ratcheting one way. So we've got this duty of finding intent, and then at the same time, this problem of structurally how judges are being allowed to sit in their roles. And then inside the state, if we're going to the criminal side, you've got the question of prosecutorial discretion. Is the prosecutor going to go after somebody who's a cop as opposed to something else? You don't get points with the police union going after a cop. I believe there's never been a case where a police union has said, we agree, this is a bad actor police officer. So as a consequence, you're just got a one-way ratchet right there. And since prosecutors have to work with the police all the time, there's kind of this relationship that is there that makes it, in that prosecutorial discretion, they work, as you've seen many, many times, how they go through hoops to try to find a way to maybe not prosecute in that setting. And even if they do prosecute, they kind of seem to do it in a way that they end up getting an acquittal. We'll see what happens with regard to the murder of George Floyd. Anyway, all I want to say is that that's the state level. At the federal level, of course, you've got the political thing. Obviously, district attorneys in the federal system are not, quote unquote, elected, but they are under the, they are chosen by the president and confirmed by they're confirmed by the Senate. And of course, you have all these issues with regards to these people, with regards to their role within the Justice Department and whether the Justice Department is taking a proactive approach as part of the generic policy with regards to protecting these rights and dealing with things like the police kind of violence that we saw that happened with George Floyd or not. And that's the political reality that you have there. And then you have how much independence these prosecutors have. And then you've seen situations where all kinds of prosecutors have been replaced by a new president and they put in place their own kind of people who are also maybe going to be kinds of people who follow along with the logic that they expect of whatever's the kind of policy. Now, I know they're supposed to be independent. I'm not saying they're not. But these people are ambitious, smart people, and they can read tea leaves. So when they got a choice between doing this or that, they might decide in their prosecutorial discretion to do a little less. You just saw that what the head of the Civil Rights Division at the Justice Department just resigned, right? So you see these kind of things happen where there's people who may be very good at doing things, and then they turn out, I'm leaving, I can't handle the administration that I'm dealing with. And that is part of the dilemma that you have at the federal level. So that's the state and federal thing. Now, if a state, somehow a state DA brings a case for a criminal prosecution of a federal official, what happens? They bring it in the state court, Federal Officer Removal Act, send it to federal court. And at that point, the judge will look right at the beginning to say, hey, is this officer, was this federal officer working within the scope of his job? Was the rule clearly established? And did they act reasonably? If they did, they're going to dismiss the case and it dies. If they think that the officers acted outside of that, they might remand it back to the state court to go ahead. And there are a few cases of that. But the bottom line is there's a broad protection for a state court trying to go after a federal officer. Similarly, with regard to a federal prosecutor trying to go after a officer for criminal violations of some kind or hate crime or something like that, you got to look at the laws, and the laws kind of make hoops pretty high, okay? Now, you might be able to get some kind of civil or consent decree thing that worked out. But in terms of criminally prosecuting an officer that's a state officer, hard to do unless you're going to have something like, I don't know, bribery or something like that. But for actually beating up somebody on the street, you're not going to see that kind of criminal prosecution prospering at the federal level because it's hard. I'm not saying it's impossible, but it's just very, very doubtful. Let's talk about some other parts of the system. The judiciary, judicial folks, they have immunity when they're in their judicial acts, pretty much. And so as a consequence, unless it's a kind of thing where somebody's taking bribes or something like that, you're not gonna, you've got these decisions where somebody's always, sending people to jail for 30 years or something. I guess they can be overruled by the judges above, but whether, again, if they're elected judges, are you tough on crime or not? Are you gonna allow this case to go forward against this officer? There's a lot of relationships here. Moreover, you got to think about the fact of, in a number of cities, what comes in from the police department helps pay the budget, right? Those tickets and all that stuff that people have to pay and for jaywalking, whatever. It's a revenue stream, and there are even private entities that are part of this revenue stream for getting those collections. And then you've got the prison system and the private entities that are making money in the prison system, and they all have an interest in a repressive structure of things happening. They're private, but they might have a contract that says you got to guarantee 80% capacity at the prison if we build it there. Well, to get 80% capacity, you got to have flow. So where are you going to get flow? Let's look for the most vulnerable people, and typically brown and black people are not going to be people who are going to have the resources to fight. And so they're the easy targets in this game. I hope you see the problem that you have inside this American game played out between the state and federal levels and the different roles that are there. Now, there's another way to think about all this, which is it's not just a state and federal game. It's a state, federal, and international game. This is something that you maybe don't think about, and most times in law schools, they don't think about it, but most of you out there should think about this. We're not just a state and federal inside the United States, separation of powers and federalism game. We're a state, and we're a state, the United States of America, that's operating on the international plane. And so the game is really not just this individual or class civil action or state civil or criminal action or federal civil or criminal action. There's also a foreign civil or criminal action. Yes, a foreign or civil or criminal action. Like, just imagine if that guy who got punched in that setting, or maybe those Australian reporters that were beat up at Lafayette Park. Australia may have ways to say, we're looking at the claims of those particular people, and we as Australia, not just those two people who are those press people, are saying to the United States, we have a problem with how you act. Or you've got these people who are dual nationals. It's an example. Anyway, but in addition, you have an international level, both at civil and criminal. For example, there is the Inter-American Commission on Human Rights that the U.S. Is party to, and under that, individual complaints about what's happening with human rights can be presented there. If you were ever watching TV this morning, you saw that the UN High Commission on Human Rights had a whole morning this morning looking at the systemic racism issue in the United States and other countries. George Floyd, George Floyd's family, Trayvon Martin's family, Eric Garner's family, all these black people that you think of in this domestic American state federal game were there in Geneva, I think it was in Geneva, at the hearing, and had contacted the international level to say things are going bad in the United States, and our human rights are being violated. Help us. And many people have done that with regards, or many organizations, the National Bar Association wrote to the international level saying, help us. And you can look at regional level international organizations like the Inter-American Commission on Human Rights, or at the purely international level entities like the UN. And there are other entities like the World Health Organization has got one of the important points is health, importance of respecting, making sure that people are healthy. One of the things that no one in the United States usually thinks about is something called the Universal Declaration of Human Rights. You don't hear about that most of the time in the United States. You don't hear about it on the news. You don't hear about it anywhere. It's always in terms of constitutional rights or civil rights or this statute or that thing. Whatever. I told you about the inside US game. But you look at the Universal Declaration of Human Rights. It was done back around 1948, I believe it was. And it has 27 articles. And you need to read those articles, because those are basically every state in the world at that time that come with colonial powers voted for this declaration, and the few who didn't vote for it abstained. So you kind of had a consensus, all right? And it was basically saying, and the first article is this one: every person is born free and equal. That's a human right. It's not something that's tied to our Constitution or our structure or our state and federalism or our separation of powers. It's a right you have as a human being. You are born free and are equal. Now, you say, come on, Professor Davis, get real. Look at what America is. The point I'm trying to make is you have that right. Whether that right is recognized inside the United States with the way the games get played in the United States, that's a different thing. But you are not just somebody who is a tributary to whatever games get played in that state and federal game. You have rights. There was a person named Derek Bell who used to talk about interest convergence. He said that Black people would not move ahead unless there was convergence with white people's interests to do that. That's an inside American game. I'm just one to posit that may be true, but the bottom line is that if you don't recognize that you have these basic rights that are human rights, and human rights have been looked at back through slavery too, then you're just being caught up in a typically only American game. And that's unfortunate. Now, there's other things. There's the International Bill of Rights, there's the International Covenant of Civil and Political Rights, the International Covenant of Economic, Social, and Cultural Rights the U.S. hasn't signed. Okay, that's treaty obligations. There's the International Convention on the Elimination of All Forms of Racial Discrimination. There's the Convention Against Torture and Cruel, Inhuman, Degrading Treatment or Punishment. These are all treaties that have been signed by the United States that U.S. has as an international obligation, okay? And in addition to that, there's something called Customary International Law, which is the usage of states. And most of these things rise to that high level of being customary international law rules. Now, one of the things about international law that I just want to throw at you as part of this thinking is one of the basic rules of international law is, guess what? No state can use its internal law to extract itself from its international obligations. So that state and federal game that we're talking about, where, you know, Congress passes this or doesn't pass this or this training thing or all that, yeah, that's all part of American law, but that's all domestic law. Your view, I hope, would be, hey, but is this thing protecting my human rights? Is this thing protecting my human rights? And if you start from that basis, then you look at things a lot more differently than you do in terms of just this little game inside the United States. And it's important. Why? Because, in case you didn't notice, in Geneva, they were talking about the United States all this morning, all over the world. In case you didn't notice, there were people demonstrating about George Floyd all over the world. Those are your allies. You know, we get this game of trying to have us hate the foreigner and all that stuff. That's to play you in a game. You need to understand those people are your allies. And with the internet and social media, you can get things together. I'll give you an example. You know those folks who work at Amazon, okay? They've been talking about this COVID-19 and the way that Amazon's warehouse is set up. They've been really upset. There's a guy who got fired. He's bringing a lawsuit in New York against it, right? Well, guess what? The same problem at the Amazon plants in France. The same problem with the warehouse where France has stronger labor laws. And the union over there brought a lawsuit against Amazon over there about how it was operating its warehouses and all that. And the judges said, you are right. And they ordered Amazon to basically, they took out the catalog Amazon and said, okay, this is the stuff during the pandemic you can ship. None of this other stuff, just this stuff here. And you need to get this ready in 48 hours. You need to consult with the workers and make sure the place they're working is a safe place and all that kind of stuff. That was a court telling it. Now, in the United States, guess what? Those French folks have written an amicus brief in support of the American action against Amazon. Because Amazon's playing worldwide, right? But these French folks are talking about what they've had to deal with in France to help the Americans in their quest, these American workers, to be not working in a COVID pandemic crazy environment. That's how you can have those allies out in the world, by having those connections like that to help strengthen what you're trying to do in the United States. Because if there's one thing you can know about the United States is that even with the current administration, we are very, very conscious of how we look in the world. If you look back to Brown versus the Board of Education, ancient history, 1954, you'll see there was a lot of thinking about, well, what the Soviet Union, what the world is thinking about segregation inside the United States, okay? As part of getting that change to happen in that law that was there. So I'm getting now to my third point, which is around the COVID-19 overlay. Let's think of all the ways that people are trained to act, how people act in demonstrations, how the police, how the National Guard, all those people, all that swirl that we see, people going to the beach, all that stuff you do every day. And now you got COVID-19, a pandemic. All right? In case you don't understand, COVID-19 doesn't play. You may think all kinds of crazy stuff about whether this is real or not, but I think 100,000 people dead is pretty real. And they're estimating we'll have 200,000 dead by October. So I've had people I know who have died of COVID-19. And when I talk to doctors, I have a friend who works up at the Kroger up here, who's talking about her brother who works at a hospital. He cleans the machines. 12 people in his department got COVID-19, okay? I saw a guy survive COVID-19. He had an $800,000 hospital bill. So if you don't believe that this thing is real, let me talk money, because money always works in the United States. $800,000 hospital bill, don't worry, his copay was only $200,000. So all you people out there listening to this, if you think this thing is something, is just a play around thing, you are so, so wrong. And as I love to say to people, say, I don't need to wear a mask and all that, I say, hey, fine, 3 weeks, okay? 3 weeks, we'll just wait 2 weeks, maybe 3 weeks. And as you can see with the numbers that are rising in different parts of the United States, that's where we're at. This is a very, very contagious and deadly disease or virus. And they don't know what they're doing. And please do not believe the happy talk. And if you listen to around the world, people like in Canada, you know, right next door, they're saying this thing's gonna be around in 2023. You know, let's talk about a vaccine being here by the end of the year. Trust me, promises just before a presidential election always happen. I can remember back when Nixon had a secret plan to end the war in Vietnam in 1968. Didn't want to tell us before the election. I don't believe it. I don't believe it. I only believe it when the vaccine happens. So you wear your mask, you stay at home, and what is the third thing you do? Wash your hands all the time. Okay, this pandemic is going on. We can talk about police violence and all that stuff. We can talk about those images that we see. Let us talk about the use of riot control chemical agents and projectiles on peaceful protesters. Think about that. What does tear gas and pepper spray and those other kind of things make a person do? Cough, sneeze, their eyes water. And so if we have numbers like, for example, in Spain, it said that there's an estimate that 5% of the population had COVID-19. What you've just done is you've taken people who have COVID-19 in these spaces and you have turned them into vectors for everyone else, because they're going to be coughing more, they're going to be sneezing more, they're going to be rubbing their eyes and touching things, maybe those milk bottles to pour over their eyes, that milk will have it in it and all that stuff. And you're turning people into vectors, almost like they were weapons for biological effort. In addition to the impact on them, obviously, tear gas has an impact on lungs and all that kind of stuff, making them more vulnerable. And notice, I'm not talking about people with comorbidities, people who are, have certain weaknesses. I'm just talking about structurally the use of this kind of technology and the projectiles, obviously, that hurt people and all that, but the use is insane. I want you to hear that word. The use of that in the context of a pandemic is insane. It's like using a chemical weapon on people, because you have the people who are sick become the vectors for the people who are not sick. By these coughing and spitting, I think, or somebody coughs or sneezes, it's like 200 million of these droplets goes out in one of those coughs, from what somebody named Aaron Bromage said. You only need 1,000 to get infected. And if you think I'm crazy saying, oh, chemical weapons and all that, there's a judge in Denver who passed a temporary restraining order against the police there to say you can't use those chemical weapons against those protesters who are peaceful in Denver. And there's another case that's going forward in Seattle that the ACLU and the Korematsu Center and others have done to do the same thing. What are they arguing? Are they arguing human rights under this treaty or that? No, they're going on the Constitution. Article 1, what is it? First Amendment and Fourth Amendment rights. That's where you find in the local US law things that vindicate your rights, like the right of assembly and all that stuff, as at the international plane, which is a human right that you have. You're just looking for the local law. Which part of it can I use? Is it the state constitution, the federal constitution? Is there some state statute I can run on? Whatever. You find the law and they're running it and they say, oh, okay, we're going to go with the First and Fourth Amendment. Those seem to be the ones that work to protect these people from the insanity of the use of chemical agents against them. Now, my personal view is, with all these immunities and all that stuff that these officers have, there is no situation in a pandemic where it is reasonable to use any one of these agents against peaceful protesters. It's not reasonable because of this pandemic creation risk. Now, will those judges who hear those cases who are elected or want to please and get promoted up from district court to appeals court and all that, will they be willing to say that? Here's the kind of thing you're going to run up to, and it's coming down from the Supreme Court. The problem is, the Supreme Court would say, like for a Bivens type claim, well, it's not clearly established that in a pandemic, these ways of doing these things are not, the law is not clear. It's not clear. So how was the officer supposed to know? Again, it's the game, like that intent game. How is the officer? It's not clearly established. We're in a pandemic. How are we supposed to know a pandemic is going on and what to do with it? We can't even get people to agree on what's the basic things of wearing masks or not. We're getting all kinds of stories from different parts of the country, the reopening, the closing. I just saw that all the restaurants and bars that were open a week ago in Florida are being closed. Why? Because the corona don't play. All right? And so what I'm pointing out to is there's all this confusion, and then the court say, well, it's not clearly established, and so the officer acted reasonably, and yada, yada, yada. And that means that those kind of cases probably don't prosper, and it's tied to that intent thing. So what I've tried to say here to you is, first, I talked about the slave statues and taking them down. Second, I talked about what happened to these people in Bethel, Ohio, trying to demonstrate and having all this pressure on them. Third thing I talked to you about is you understand a state-federal game most of your life. What you need to understand is that it's not just a state-federal game, but it's a state, federal, and international game. And that's what people are looking to see whether they can operate individually, they can operate through their state, they can operate through the federal government, they can operate through a foreign government, they can operate through some regional or international human rights body to vindicate their human rights, not being caught up in this kind of shell game or between state and federal that happens in the United States. And with all this going on, we have a pandemic that is going on that I think should reconfigure any visions of how state violence is used against people. I will finish with one point, and this is hopefully this will be enough to help finish up this conversation. We all saw the George Floyd video, okay? All right, it's horrendous. But you know what's the worst video? If it's possible to be worse than the 8 minutes and 46 seconds, it's the video of the people who are around pleading with the police officers to get off his neck. It goes on for about 2 or 3 minutes. I still can't get over it. These are decent, all kinds of people, white, brown, men, women, saying to the cop, please, black, hey, get off him. Get off him. He can't move. He's not moving, whatever. On and on. Then you had 9/11 supervisor contacted by the 9/11 dispatcher, said, hey, I'm sorry, I don't want to be a snitch, but this doesn't look right. Then you had, I think, a fireman walking by, saw this on off duty and said, hey, this doesn't look right. So don't tell me there was no notice of what they were doing, okay? And so that's even worse, because what that is saying is that picture, and I still see that haunting face of Chauvin there with his knee on that guy, basically saying, I can do this and I can get away with it. Because why would somebody think that? I go back to this point, way back in our history, it goes on for 400 years. It's a fundamental problem in America. And it's tied to this whole shell game, which is that, well, let me explain it to you this way. I used to live in France. Every once in a while I run into white Americans who were looking around in Paris trying to find something. I'd help them out in the subway. And they say, oh, so you live here? Yeah. Oh, you must miss the United States. And I always get that question. There's a little nervousness in their face about that. And what I finally came up with was this answer. In France, I know I'm not French. Therefore, I'm not civilized. Why? Because the only people who are civilized are the French in the world, okay? But in France, I have no doubt that I am human, that I am considered human, okay? And I say, in the United States, there are times when I've wondered whether there are people who think I'm human or not. And that's the heart of it, because we were treated like cattle in slavery, and that slavery thing, the past is never over in the past. The past never goes away, as a great Southern writer said. And that past is here. It permeates this country in so many ways that are unconscious that you can't imagine. At the heart of it, it is the sense that, oh, black people have to be inferior. Or maybe the flip it the other way, white people are better or are superior. I mean, it's not as direct as the sort of back things with, our friends in Jefferson Davis and the secession thing and all that, but that's what it is. So I'm telling you, trust me, that's not only in the United States. I mean, there was a minister of information in
Professor Davis, I hate to interrupt you.
Okay.
You could wrap up and then we'll do some Q&A. I'm sure many of our participants would love to ask you questions.
Okay, so what I'll wrap up with this story about a minister of information of Singapore at one point who had said, oh yes, there's a hierarchy of races in the world, We're talking with Asians at the top, of course. It's always amazing how people always decide that their group is at the top. I know. And then there are white people, then there are brown people, then there are black people. I mean, it's always people play these trips to rationalize what they're doing. But all I'm trying to say to you is that you really need to get out of the shell game of between state and federal in the United States, see yourself as having human rights, and then seeing about how you can vindicate those rights in that American system. And that the COVID-19 pandemic, I think, is a very strong basis for attacking a lot of things that are going on because of the danger that everyone is facing. Do not sign a COVID-19 waiver with regards to your work. That's the last thing I would leave. All right, I stopped there.
So we are now at 5:55, so I'm going to just wrap up. I want to thank the participants who...
Oh, can I say one thing before you wrap up, Sahar?
Oh, yes, go ahead. Yes, please. Well, thank you, Professor Davis. Thank you, Professor Farley. You gave us so much food for thought, so many things to think about, many books that still need to be read, including more of your work that is on my list of things to read. I just want to put a final pitch for the Center for Security, Race, and Rights. It is not easy to have these types of events. For those of you who have heard various discussions about current events and about law and about politics and public policy, taking these radical counter or subversive perspectives is something that doesn't earn you a lot of friends. But with your
You're
support.
speaking the truth. Nothing about what you say is controversial, subversive, or anything. It's just the truth. Okay, sister? And so
It
don't
is the truth.
help
It is
them.
the
Help
truth.
them. Help her. Give
Every-
her money. Do whatever you can to help her.
Everything I have said is as old as the Christian's gospel, right? So but I gave nothing but Matthew 25 in my entire presentation. And I didn't give it.
Unfortunately, that's not the mainstream, but you're correct. I mean, the problem is that, with the mainstream media and with the victors who are writing the history, controlling the media, controlling the law. But I say that just to tell the participants, essentially make a pitch to support our center. Go to csrr.rutgers.edu, press the donate button, and give whatever you can, because we are very intentional and very purposeful about being a center that takes these grand, big ideas that one can call radical, one can call controversial, depending on where you sit. But I think based on the place we are in America in terms of our legal system, in terms of who's occupying the White House, who is sitting on the bench, who the prosecutors are, we do have a major crisis of legitimacy and a crisis of leadership, among other crises. And then also, if you're on social media, please follow us at Twitter at RUCSRR, Instagram, Rutgers CSRR, and on Facebook. And finally, I hope to see all of you on June 24th, next week, 4 p.m. Eastern Time, to hear the brilliant Professor Gina Shaw, who is at City University of New York Law School. She will be addressing social justice lawyering during pandemics and uprisings. So thank you very much again to Professor Farley. Thank you to Professor Davis. And as we say, onward and upward. Goodbye,
Yes,
everyone.
sir. Yes, ma'am. All
Thank
right.
you.
Peace to everybody. And she's a great person. You're looking at folks out there. Just remember, she is a great person.
She is a one-person faculty. You could
That's
be
right.
like, you like I mean, you have great faculty colleagues, but Sahara's like basically 50 people
Right.
in one very energetic bundle.
If you want a model for how to be Sahara, watch her.
Thank you.